Hi, and welcome to another DPO advice from Steve. Today we're going to be talking about releases to various public sector bodies of medical information, but focusing mostly on releases to public organisations, the police. This is England and Wales law, and in particular the London picture, which is where most of my clients are at the moment. So if you're a customer needing specific advice, feel free to contact us. So, firstly, let's talk about sharing with other practitioners for the purposes of care. That does include adult social care as well as medical care. This is a legal duty in England under Section 251B in the Health and Social Care Act, so long as it's likely to facilitate the provision of the services or in the individual's best interest. Now, the individual has a right to object to this, and also we have to take into account if they would be likely to object. And it doesn't include the anonymous access providers. These tend to be people like sexual health services, don't require names to be provided. But for the majority of cases and patients, you can share data as required for health and care purposes. And in fact, we've got loads of shared care records across London and shared access to patient records to achieve this. Where a patient objects in primary care, it's generally recorded as no GP electronic care record sharing. Now, the patient can, of course, give you a specific agreement to share data for a single purpose, say a referral that overrides this, but the patient must then choose to do so in each case if they put the exemption on there. We can't share if they've said they object. So that's the basics for health and social care. Okay, bear in mind when I talk about sharing data, adult social care data only, that does include children moving into adult social care, so it doesn't mean just over 18s. Sharing of children's data is under slightly different rules, which I won't cover here. But let's now talk about police sharing. Now, the police in general have a right to ask for data, but we're not required to provide it. We're allowed to do so. But in most circumstances, without a court order, there is no obligation on us to do so. Now, the London Metropolitan Police are quite good about this. They use two main forms to ask for data. Now, other forces may have similar forms, but they probably may not have the same numbers. So Form 172 is a request to release medical or treatment information with the consent of the data subject. It should be signed by the data subject. Now that's common where, say, there's been a treated physical assault, where someone's told the police they have health issues may affect their behaviour, the police need to verify, or where someone's in custody and they have medical requirements. These are generally fine. The data subject consented, we can release, and I'd recommend providing unless there's particular special circumstances or risks. Please feel free to contact me if you've hit any of those. Form 3022 is the Prevention and Detection of Crime form. Now, this must include the legal justification for the request being made. If it doesn't, or they haven't explained it, reply asking them to complete it, because without that, we haven't got clarity we could use as exemption. The general exemptions they use here are Schedule 2 Part 1 of in Schedule 2 Part 1 of the Data Protection Act, usually paragraph 2, which allows data prevention, technical crime, apprehension of prosecution offenders. Now, this is normally without the knowledge of the data subject, and in general under this exemption we don't have to inform the data subject if it would prejudice the purpose. That creates a bit of a moral dilemma because, of course, we all prefer to be open with our data subjects. But in general, we won't know the full details of the investigation, so we can't be clear what harm be caused by telling the data subject. Hence, if you are using this exemption, I recommend you don't tell the data subject you've shared the data unless it's very clear that the police are happy for you to do so. Now, bear in mind of this exemption, we can share, but we're not required to do so. It's generally considered a good thing, obviously, to cooperate with the police and civil society, but it does mean if there are special circumstances, we can consider these. It does happen rarely, but feel free to consult me so I can give you more formal advice if you're a customer. Sometimes police will ask for other reasons. Common ones you hear are to do with the welfare of the person, such as proof of life, missing child, or missing high-risk individuals. They're also sometimes asked in respect of the counter-terrorism prevent duty. These are all safeguarding concerns, and we'll look at those in the next video where we cover safeguarding. In general, it's reasonable to share data if there is a person at risk involved, but we'll go into more detail in the next video. As usual, if you need detailed assistance and you're a customer, feel free to contact me. There's no usage charges on any of our health contracts. If you're not a customer, email us at sales@excathedral.solutions if you'd like to become one. Thank you and goodbye.